Hello, how are you? This is Mispa Chaudhary, immigration attorney from Mispa Chaudhary and Associates, PLLC, immigration law firm. Today is Monday, October 12th, 2020, and we are here to discuss a very important subject or very important matter which has been questioned a lot, which is public charge. And we receive all these inquiries over here where they are asking for the questions whether the public charge applies on me or it does not applies on me, and how it works. So there are briefly we will discuss the public charge issue, and we will discuss who it implements on and on whom it does not affect. You can see our information on the screen. The scrolling screen, it gives our information, the website information, telephone number is there, email address is there, our Instagram, our LinkedIn, our Twitter, our Facebook. So you can contact us there at all these mediums. Also, you can contact us on our website. Also, that information is there if you have any questions or any concerns. We respect your opinion and your question and any inquiries with regards to the immigration issues. So we will briefly start discussing what is public charge. So a very brief and precise definition of the public charge is that public charge is a ground of inadmissibility. So these are the grounds or reasons based on which an immigration officer at the consulate can deny the entry or the can deny the entry or the immigrant visa to the person who is trying to do the entry within the United States and as an immigrant. So there can be immigrant and there can be non-immigrants, but the public charge is related to the immigrant visas. So this is the kind of visa where they can be denied, saying that no, it's a ground of inadmissibility in addition to certain other grounds of inadmissibility. So now who it is implemented on? Green card, the common language, immigrant visa, you can get based on the family sponsor as well as the employment sponsor. So this public charge is particularly related to the family sponsorship. So the people who are being sponsored by the family members and the green card process is done or the immigrant visas are processed and they want to enter United States as immigrants. So this applies to them. It does not directly apply to the employment-based green card process, because over there the employer clearly says that he's the sponsor and it has certain different requirements to establish the ability to pay the pro-offered wages and not to become a public charge for the employee once he is in United States on the immigrant visa. Secondly, very importantly, when it starts, how it all story begins. It was in the system previously with different names, different definitions, but in late 2019 the government implemented this as the public charge and as an inadmissibility account. So once this rule came into the possibility or into the books, and they said, okay, we are trying to implement these regulations, certain injunctions were applied through the courts in New York, in Vermont and Connecticut, and they said that we are not going to apply this, or we are not going to implement this, the public charge rule on our immigrants or the people who are trying to enter into the United States as the immigrants or changing status as the immigrants. So it is applying two-way. One way is on the people who are trying to enter United States from outside. They are doing the consulate process. They are going through the immigrant visa process through consulate. That is as a ground of inadmissibility can be applied over there. And then the second theme is that the people who are applying within the United States, they are filing for the adjustment of status. On them also, there were certain forms and applications added in where the immigration requires certain information stating or proving that they will not become the public charge in the future once they become a permanent resident or once they become achieve the green card. One more thing is that the many very much asked question. It's during the days of these pandemic, what is going on, during the days of this COVID-19, people concerned, healthcare issues, certain other issues are involved, people are getting unemployed, and they're asking, what about the public charge thing, whether this is going to apply on us? As per the USCIS notification, they have mentioned that testing and treatment, even vaccine for COVID-19, once it's out, will not trigger public charge. So USCIS, Department of Homeland Security, has given the statement on that it is not going to apply on the testing and treatment and vaccination if somebody is getting that advantage or is getting this benefit for the treatment, for the testing, or once the vaccine is out, taking that vaccine. So that is clear. Further, in states like New York and Vermont and Connecticut, these are the three states, is that where certain other programs, so programs including food programs, program including housing, programs including public benefit like housings and the healthcare and stuff, and these states have clearly mentioned that the public charge is not going to trigger in any way, and the public charge concern should not be triggered for the people in those three states. They are very clear about this. Furthermore, there are certain kind of visas other than the employment-based visas. There are certain kind of visas or certain kind of visa holders on which the public charge does not apply. Those include T visa, those include U visa, the victim of violence. T visa is the trafficking visa. Those include the refugee status holders, and those include on the asylee status holder. So and certain others also included there, but these are in particular on which the public charge is not implemented. So basically, if we go through that in detail, that okay, what kind of immigrant visa petitions trigger the ground of public charge as an inadmissibility. So that is particularly the family-based process based on which you need to provide them with the proof. You need to, the sponsor and the petitioner, the applicants, they need to provide the proof that they will not become a public charge in the United States once they are the green card holder or once they have the immigrant status. Furthermore, a very importantly asked question is that whether it implements in the naturalization process. So people are the green card holder and they become eligible to file for the naturalization or to file for the citizenship application. And they said that okay, whether it is going to implement on me, so it do not apply in the naturalization process. Simple. It is basically implemented on the green card process, basically family-based green card process, and the people who are sponsoring based on the family-based petitions and stuff, they need to provide them with the proof that the person who is the intended immigrant or who is within United States and filing for the adjustment of status to get the green card based on the family petition qualification will not become a public charge and will not trigger the grounds for the inadmissibility based on these grounds of inadmissibility as the public charge. So this is the basic description and basic brief explanation. And I know there are certain questions people keep on asking, our clients ask us that whether it's going to implement on me, whether there is going to be any separate application which we need to submit. So yes, there are certain applications that are different. The application which is added in along with the adjustment of status process, and the application which is added in if it is going through the consulate process, and you need to submit those documents along with like affidavit of support, along with your Department of State applications and forms which you need to submit with the Department of State. You need to add in these public charge forms and provide them with the proof along with the evidentiary proof and the supporting documents that this person, this intended immigrant, will not become public charge once he will be granted the green card status, and he will not be effective for the monetary charges or for these benefits on the government of the United States of America. So I think so we have briefly explained this process. If you have any questions, we can respond to these questions. There are certain questions which were asked to us online, and we have tried to respond to them, as I have always said. But if there are certain questions that you want to add in, you can add in those questions here, ask us, and we will try to answer those questions. There are certain concerns which are in front of me, which we have tried to put down. So if they are related to our subject, or maybe they are not related to our subject directly, but these are the immigration related questions and people ask us, we try to answer those questions. One of the questions which is sent to me by Tasneem from Vermont. So this lady is asking about the journal question that if somebody has applied under premium processing, how many days the process should be completed in. So the question is, which in my understanding is that the question that if somebody applies for under the premium processing, usually how much time period is taken on that in processing it. So once you apply for premium, once you get the receipt notice, there is a 15 days time period during which the immigration officer has to work on your petition. During this, either they will work on the petition, they will complete the case, they will give their decision, or when they go through the case, they can ask you for more documentation. They can see that, okay, we have reviewed your case and there are more documentation that you need to provide to us. So in that situation, they will send you a request for evidence or an RFP listing the documentation and listing the query which they have, and you need to answer those, provide those. Once you send those documentation back, they will have certain time period to work on it, and they will issue their decision on that. So I believe this is the answer to your question. Another question which was asked here is that about the U visa. I was a victim of violence during my job at a cell phone store. I got robbed on the gunpoint, and what are the options available for me to apply? This happened in the year 2016. Now, there are certain requirements when a person can apply for the U visa. U visa, like it says, is the victim of violence visa. If you or anyone who has become the victim of violence or get into such situation where their life get endangered, and they call the cops, and the police they get a police report, and certain charges have been placed. They can based on that they can apply for the U visa. And U visa certain times is that it should be as soon as possible. It should be as soon as this incident happened. But sometimes people don't know even that what has happened, whether they have any relief available within the immigration system if certain things or certain incident has happened to them. So in that situation, even if some time had passed by, but the case is still open. The case is open, the culprit has not been caught, the person is still at loose, the case is still open in the police department or before the law enforcement agencies, then you are still eligible to file for the U visa. But it's always advised that to file your U visa as soon as possible if anything like this happens to you and you qualify under the U visa qualifying list. Okay, now this is the lady, Rabia. She sent us the question. This is from North Carolina, and the question relates to she has applied for the B2 visa because she was extended stay over here in the United States due to pandemic and flight cancel. She has not heard anything about that B2 extension what she has applied. So what she needs to do? It depends that if you have filed in a timely manner. Keep this in mind. Number one point, very importantly, you need to file it in a timely manner. If you while your B2 stay is still valid, if you file it in a timely manner, they can take their own time to process it. And keep this in mind that immigration is in is in limbo, or you can say that their processing time has increased. So while it's still in process, you got your receipt notice, you are waiting on the decision, and you think that okay, like it's 15 more days, the time period which you have requested on B2, there are 15 more days to process it, and to the date of the validity which you have requested them for the extension, do file the B2 extension, the second one, and ask for the, if you are still here and if you cannot leave or you want to file for a second extension, do file it in a timely manner and request for another extended 6 months on that. Do not wait that they will just decide on it. I once filed, they'll decide on it. They will decide and give you, even if they prove the case, they will give you the 6 months time period and the dates, validity period which you have requested on that application. So if that date is passed, even if they approve it, it's not going to help you. So it's very important to file it in the timely manner, the second extension if that is due, or for another change of status if that is the required one. The change of status can be filed. The basic requirement is once you are in status. So if you have entered United States on a visit visa and you are here 2 months, 3 months have passed, and you want to file for the change of status, you can file for the change of status because you still have the validity period available on your B2 stay or a visitor stay here. But once you file for the extension of stay, it's a pending status. They have not yet given you the status. So in that situation, you first need to wait for the approval of the B2 extension, and then you will be eligible to file for the change of status. So it is very important, and that is, I have stressed many times, it's very important that if you are planning to file for the change of status within United States from one visa status to another, file it in a timely manner, and file it during the approval or status situation. Do not wait that you have to waste all that time and file for the extension and then wait for the approval of the extension, and then you become eligible to file for the change of status again. So it's a waste of time, it's a waste of your planning, and whatever you are trying to achieve with the immigration thing, it becomes very complicated and time wasting situation. So it should be avoided in all times. Further, there is another question which I have over here. It's about the adjustment of status. They have filed for the adjustment of status, but once they file for the adjustment of status, the wife is a US citizen. This question is from New York City. The wife is a US citizen, and the husband, he has apparently accumulated some unlawful presence and overstay within the United States. His entry was legal. What are the options available for them? So the name is Sumera. So Sumera, your question is that the spouse, the wife, she's a US citizen, and she got married to a person who has come legally into the United States, maybe visitor visa or some other status, but has accumulated unlawful presence or has accumulated overstay time within United States. Whether you are ready to file for the adjustment of status, so this is the question I understood. Yes, if you are married to a US citizen, there are certain requirements under Section 245 which makes you eligible, that even if you have accumulated time but your entry is legal, like your entry is legal, there is a stamp available, I-94 available, your entry is legal, then still you are eligible. And if you are married to a US citizen, you are still eligible to file for the adjustment of status. If you have, there are certain requirements, certain criterias involved. If you are interested, if somebody is linked with this kind of question or with this kind of issue, kindly do contact our office to schedule an appointment, and so we can go through the documentation and we can talk to them in detail and let them know whether this eligibility applies on them or not. Here, this is Naima Azmat. Naima's question is, if a green card holder got divorced from his second wife and wants to apply for his 10 years old son only, can he do that? He didn't mention about this child in this immigration, so are the officers gonna question that? Okay, let's read it again. Okay, the question is that a green card holder got divorced from his second wife and wants to apply for his 10 years old son only. Can he do that? Yes. Even if he's a green card holder and the son belongs to this guy, he's the father of the child, divorcing the wife does not break the relationship between the child and the father. So father can apply based on his green card for a minor child. Yes, a 10 years old child, he can definitely put in the process and do the family based petition, file for that child, and can get him here on a green card. Also, he didn't mention about this, that his child is in his immigration. So are the officers going to question that? Now this is important. It has certain small questions in between, like sub questions in it, which need answers and which need clarification. So you are saying he did not mention while he was doing his own immigration, he did not mention that he has a child. There can be so many reasons. It can be it's avoided purposely, or it was left behind. What happened? Has the officer any concerns about that? Keep this in mind, that all of these concerns needs to be answered to give an accurate answer with regards to that, what can happen. So Naima, I highly recommend, because there are certain so many questions in between and queries in between, I highly recommend that for a clear answer, you can contact our office and talk to us in detail, or the father of the child can talk to us in detail about the queries, sub queries in between, so we can give you a precise, correct answer with regards to that. It's very important, because half-asked questions are half-asked answers, and maybe the answer is not right, or the questions you are asking, that is not conveyed completely into the answer. So it's very important that it needs to be addressed in detail. What are the options available? What were the possibility? What happened at that time? So all of this is very important. If he missed on mentioning, still there are so many ways to prove that the child, he's the father of the child, and based on that he can apply for the family based petition for the child and sponsor the child. Okay, you have our information on the screen. You can see that scrolling down here. You have our email address, you have our telephone number. Where you have any question, any concern, you can ask us and we will try to answer that. It should be precise. If you have a detailed concern, if you have a detailed facts involved with regards to the immigration matter, it's always advised to take appointment, come to our office. You can take appointment through Zoom, you can take appointment through Skype, telephone, in person, and talk to us. So we can have all the details, all the detailed question to answer you a detailed answer. You are very welcome. If there is any other question, you can ask us. Further, there is one last question which I have over here, which I have taken from, which was asked on the Facebook to us. So this question, this is Gilbert, Mr. Gilbert, and he has the question with regards to, okay, the question relates to the H-1B. His question is that he's a doctor in the United States, and what is the procedure, and if we do this procedure, and I believe this question was asked by some other doctor to us in the previous sessions, but this is the question which relates to that, I'm on the J1 status, I need to file the J1 waiver, or I've already done the J1 waiver and I'm in the process of doing the H1B. What is the process involved? Number one, the answer is yes. We do all kind of waivers at our law firm. We do the J1 waiver visas. We do the Conrad 30 visas for the doctors specifically. That is the J1 waiver for the doctors, physicians, and we do the H1B also for that. So this is the step-by-step process, how the doctors enter into the United States on the J1 status. Then from the J1 step, they move forward to the J1 waiver step. Once the J1 waiver is done, if they're not leaving United States, the J1 waiver process is done, and that process then later on leads to the H1B process. So you have a sponsor clinic or hospital available or medical institute available, and they apply for the H-1B for you. Once you get the H-1B done, then there is a 3 years time period, and after that you will be eligible to apply for the green card process. So it leads to the green card process, it leads to the employment based green card. And but it starting from the J1 to J1 waiver to H1B, and to the green card process. Now let me explain one thing. Every case is different, every matter is different. It doesn't matter, maybe there is Dr. A, maybe there is Dr. B, maybe there is Dr. A from say India, maybe there is Dr. B from Australia, and they entered, or they were initially on the J1 status, they entered, but their factors can be, there can be so many different issues, concerns, facts involved in each case. Each case is different. Even it seems like that they are the same, each case is different. So please keep this in mind, no two cases are the same. So it's very important to know the facts involved, it's very important to know the concerns involved, the issues involved, and then we'll be able to decide and recommend that this is the kind of case which the possibilities available to you, or this issue can be raised while we are filing for a J1 waiver, or this issue can be raised while we are filing the H1B or the green card process based on that. So it depends. If you have any concerns, any questions with regards to this or any other issue, we highly recommend talk to us, contact us, and we are here to answer all your immigration related questions and queries. Many people have asked, I don't have the question about it specifically, but I have some time available. So I would like to talk about the 601A waiver. 601A waiver is the provisional waiver. We have, our law firm has a lot of experience in doing the provisional waivers, 601 waivers, 212 waivers, and 601A waivers. Where particularly about the 601A waiver, this is the provisional waiver, and the green card or the qualifying relative, for the qualifying relation or relative, green card holder or US citizens, they can apply for them, and it's a lengthy process, but people ask for them a lot. So I want to mention that if you have any concern about that, if you think you qualify for that, pick up the phone, call our office, take an appointment, talk to us, bring in your documentation so we can review everything. We can let you know what factors are involved and what are the possibilities available for you. Also, like I've mentioned, you can take appointment on Skype, Zoom, you can talk to us. But it's very important, if there is any issue involved, any question involved, talk to the immigration attorney so you can get a very correct answer with regards to your issues, and you know where do you stand, what are the possibilities available for you, and then you can decide that, okay, I'll go this path or I'll go this way. Okay, so I think so we will stop our video here. It's very nice to have all you guys. I can see all our guys here, and thank you very much for listening to us. Do prepare your question for the next session, Mondays with Mispa, and send us the questions, and we will like to answer your short questions. Do not send me long questions, because sometimes it's not possible for me to answer that question. If you have any questions with regards to the public charge, kindly do send us 1-line, 2-line questions, and we will try to answer them during our next live session. Also, you can come and attend our next live session, and we will like to answer all the concerned issues and queries. Thank you very much. Have a blessed day, and stay blessed, stay safe. Thank you.